All right. Good evening. My name is Bree Cummings, and I am the O'Donnell Consent Decree Project Manager. I will be your host for tonight's O'Donnell Consent Decree public meeting. Before we proceed, I would like to encourage you to invite all justice stakeholders to this meeting. The link is in the chat right now, and so if you all want to share, we would love for people to come in and ask questions and listen to all the things that have been evolving with the consent decree. Also, we would love to hear from you. Please use the Q&A section to ask questions throughout the meetings. Questions will be answered verbally at the conclusion of the meeting. All right, so to provide a little context, in 2016, a class action lawsuit was filed in federal court claiming that bail practices for misdemeanor arrestees in Harris County were unconstitutional. The parties reached a settlement that they believed was fair to both sides on November 21st, 2019. This consent decree, named after plaintiff Miranda O'Donnell, represents the first federal court-supervised remedy governing bail. Harris County is collaboratively working to implement all aspects of the consent decree. Today, we will have representatives from each Harris County party and our independent court monitors to discuss their roles. On March 3rd, 2020, Judge Rosenthal appointed independent monitor Brandon Garrett and deputy monitor Sandra Guerra Thompson. In compliance, the federal court monitors shall produce a federal report every 6 months for the first 3 years, or March 3rd, 2023, then annually until 2026. On November 3rd of this year, the 5th report was filed, and tonight we will discuss their findings. I would like to turn it over now to monitors, Professor Guerra and Professor Garrett and Thompson, followed by the representatives of the county attorney's office, sheriff office, and presiding judge of the Harris County Criminal Courts at Law. Thank you.
Great, thank you so much, Bree, and thank all of you for being here. It was really a treat for Sandy and Dottie and I to see you all in person. We did our first in-person non-virtual public meeting last Friday, but we wanted to make sure that there was a virtual option for those of you that couldn't be there to join that conversation. So it's nice to connect with you again this way, but it really was a special treat after 2.5 years to finally get to have an in-person public meeting. So we don't have a lot we want to say in terms of remarks. We'd really love to hear from you all if you have questions about our work. We're now 2.5 years into our work as monitors in this case. And our most recent and 5th report came out the first week of September. Our next report will come out next March 3rd. And our updated findings in some ways largely confirm what we've been reporting in our first 4 reports. In general, both public safety and fairness have benefited from these misdemeanor bail reforms. I think the Harris County community had high hopes for what the settlement would achieve, but in some respects, there were untested waters aspects of this. No one in the country had tried to accomplish such far-reaching and large-scale misdemeanor bail reforms. We did have a sense of how things might go because the preliminary injunction in this case did affect misdemeanor bail in Harris County before the consent decree was finalized. And we can see now with the benefit of, we're a couple of years into this, that the bail reforms under this consent decree have saved Harris County and residents many millions of dollars. They've improved the lives of tens of thousands of people who are arrested and don't have to pay cash bail to secure their freedom. But public safety has also benefited, where in more serious misdemeanor cases, there is a much more intensive and rigorous hearing. There's a public defender there is discovery. You don't just rely on a cheat sheet, really a required cheat sheet. It was a cash bail schedule where no individual inquiry really occurred in terms of what does public safety demand in this situation. And these large scale changes have produced positive results in terms of misdemeanor arrests and rearrests, right? The concern was that, well, what will happen if tens of thousands of people who are now far more eligible for release than ever before, some in what we call the non-carve-out misdemeanors, the especially low-level misdemeanors, are presumptively released at the point of booking. And the question is, well, will there be less accountability in some way? These people have to go back to court. They have to proceed with the misdemeanor cases, but they're not, held in jail because of cash they can't afford and often pleading guilty in a short period of time. during that time. What we've seen is that these large-scale changes, moving away from cash bail in most misdemeanor cases, have produced not only no increase in misdemeanor arrests have continued to decline, but no increase in new offending by those people who've been arrested for misdemeanors. In general, we've seen positive public safety. And so this wasn't surprising to those of us who were interested in the nerdy topic of bail research. There really was good research suggesting that holding people in jail for low-level crimes actually increases crime. And that makes sense if you think about the need for people who may be arrested for a misdemeanor to not lose their housing, lose their job. We also see misdemeanor arrest of people who are unhoused. And if it's a homeless person, someone on medication, someone with behavioral health needs, a short stay in the jail isn't going to change that situation and either improve their lives or improve public safety outcomes. And we note that just before our last report came out on September 3rd, an independent report by the Quattrone Center at the University of Pennsylvania was completed. They examined the same county administrative data that we've been examining during our 2.5 years of work. They focused on the time period before and after the preliminary injunction had been entered in the O'Donnell case. And those researchers found, consistent with our reports, that there are sharp decreases in both guilty pleas and jail time and more release of people following these O'Donnell reforms, but also quite positive impacts on public safety, where arrestees had, following the change, they observed reduced repeat contacts with the criminal system after these this sort of initial set of misdemeanor bail reforms was adopted. So all that is very good news. There's also a lot of hard work to do. This is a 7-year term that Sandy and Dottie and I and our colleagues agreed to take on. And even 2.5 years into this O'Donnell Consent Decree, there is still work that is in progress. When people talk about the O'Donnell reform, it's not yet complete. For example, we now have better data regarding persons flagged as homeless. We're looking into data with people with mental health needs. It means something different if someone is repeatedly coming into contact with law enforcement and they are homeless and they have mental health needs. Jailing that person may not address underlying problems that will not be solved by arrest alone. We're also trying to understand what is behind the continuing decline in misdemeanor arrests, which may be a positive thing, but we want to understand where that comes from and whether there are lessons that can be learned from it. We have also been looking at neighborhood data, looking at where are the places in Harris County where misdemeanor arrests have declined, where are misdemeanor arrests more stable. We have, as part of this work, looked at calls for service and have an understanding now that actually people calling the police in cases that lead to misdemeanor arrests, that really hasn't changed much. Other things are behind this decline that we are seeing. We also wanted to note that we've been doing substantial work to look at the costs and benefits in the misdemeanor system. What do we spend on the misdemeanor system? We talk about the cost savings that the county has benefited from because of these misdemeanor reforms. Millions of dollars in misdemeanor case processing costs. And far more money that has been saved in terms of impacts on defendants, in terms of personal, family, earnings impacts. The work in this report goes into some more detail looking at victim costs and other types of costs in these cases. We wanted to note a couple of other things that are outside our work but are related to it. Despite these continued findings in terms of looking at the positive impacts on public safety, on fairness to individuals, we've also seen a spate of news stories on people committing murders while out on bond. These stories have often been quite misleading in the way that they talk about the misdemeanor space where our work is focused, where our role is to independently report to the federal judge in the O'Donnell case. Most of the violent crimes by people on bonds are committed by people out on surety or cash bonds for felony arrests. And those may be failings of the cash bond system that's still in place in felony cases. But the only bail reform that has occurred in Harris County has been in misdemeanor cases. Second, we've seen some comments suggesting that there is a court non-appearance problem in the misdemeanor space, directly commenting on misdemeanors and claiming that people are present only less than 20% of the time in misdemeanor cases, and they're failing to appear in the other cases. What was particularly almost humorously misleading about that report was that they were counting cases where people were not supposed to be in court. They were not required to be in court. There are actually many thousands of people who do come to misdemeanor court when they're not required to be there, but that's sort of extra credit. They really aren't expected to be there. And there are many misdemeanor settings and many things that happen in court where it's for the lawyers to handle the matter. You don't need the client there for every meeting. Sometimes the lawyers are discussing the progress of discovery or the progress of diversion, and there's no expectation that the client be present. So we saw glaring errors when we unpacked the data in that study. It's actually a very small number of people that are found to have willfully not appeared in court. And there are consequences for not appearing in court. One concerning aspect of that coverage was that it suggested that, oh, it's fine not to show up in court in a misdemeanor case. That is far from the truth. This consent decree introduced clear rules around in-court appearance that were new. They were designed to be consistent, and they certainly have teeth. If someone does not appear and is found to have willfully done so, there will be a warrant. And there are bond forfeitures when that occurs. Now, in 2022, so far, it's been just 724 cases. Right? That is not a very big percentage of the total number of misdemeanor arrests. This is not a common phenomenon, but there are consequences. And one concern that we had about that coverage is that we wouldn't want people to think that there are not consequences for failing to appear in court. There are, but there are also many court appearances where the person isn't required to be there, and the cases move forward, and they can move forward more efficiently that way. Now, the county is working hard to implement this consent decree, and some of that implementation work that is coming in the months ahead has to do with this topic of court appearance. The county is planning to use funds that have already been allocated to further facilitate court appearance. And so there is actually quite active work being done to try to facilitate appearance in court, because we all want misdemeanor cases to go forward on the merits and to reach the appropriate resolution. So one last thing I wanted to mention, which is exciting, is that the data that we use, you can read our lengthy reports that come out every 6 months, and we hope that you do. We do have a highlight section. We have an executive summary every time if you want to focus on the short version. But there is also a new data dashboard that OJS has prepared for the county where you can interact with some of the main elements of this data. And I understand that they're planning to add improvements to it over time as well. But that is available on the Harris County OJS website. And it's a way that you can check, at any time, sort of what are the trends looking like in the misdemeanor space. So we encourage you to check that out if you're interested. So thank you again. It's a treat to get to present to you a second time. Hopefully we covered most of the things that we covered in person, but we look forward to talking more. I know Sandy will want to add to what I said, and we look forward to your comments and questions.
Good evening, everyone. Thank you, Brandon, for those comments. My name is, again, Sandra Guerra Thompson, and I'm a professor at the University of Houston Law Center, where I've been a professor now for over 30 years. And my involvement in this project really, we can trace back to 2010, when the American Bar Association asked if I would host a conference on bail, which I did with a lot of help. We had a statewide conference in Austin in the legislature, and I discovered that I really didn't know a lot about this process. And then I had a family member who developed a drug problem and started getting arrested in different places. And I became very familiar then with how bail worked. And I didn't like what I saw. So I have been to jails in different counties to pick up my family member. I've worked with bondsmen, and I know how that process is. I've sat next to families waiting for their loved ones to get out of jail. And what I discovered was that the system was really not working well. I mean, when I started to dig into the research, as Brandon indicated, it really suggested that a lot of people get into low-level trouble because they run into issues in their lives, and they don't benefit from even short stays in jail, very detrimental to them. This is what all the studies have shown. They're far better off if they're allowed to be released quickly, and they can get back to their lives and try to get on the right path. So my role in this consent decree as deputy monitor is primarily focused on the community. Since 2011, when I held that conference, I've spoken to people around the state, in the legislature and all over Houston, about the bail process and the need for improvement. And I continue this work as deputy monitor. I oversee a group of community leaders that include civil rights advocates, as well as high-ranking retired members of the Houston Police Department, advocates for victims of domestic violence, advocates for immigrants, the homeless, service providers of health care for the homeless, women who are caught up in the sex industry, veterans who are very much affected by these kinds of issues, as well as individuals who have lived experience in the criminal justice system. And so we meet regularly. We've had very productive meetings with many of the stakeholders in Harris County. Our monitor team has also met with Chief Finner and his leadership staff, and they have been extremely helpful in volunteering to provide their data with us, which enables us, and by us, I mean the other members of the team, to do a more thorough analysis of data of what's going on in Houston, because HPD is the primary law enforcement agency. It's one of the largest, or the largest rather, in Harris County. But we've also met with, for example, the head of the City of Houston Sobering Center, with the leadership team of Harris Health, and many other groups that have an interest in what is going on here. And as Brandon indicated, what we're seeing makes sense. There's a lot of talk about bail reform and what's happening, but the truth is that things have changed that are outside of the bail process. So we've seen a declining number of misdemeanor arrests by law enforcement across the city, across the county. We've also been informed about great progress that Harris County has made in conjunction with the City of Houston and stakeholders in reducing the homeless population across the county, and that has an impact as well. So we can imagine that a lot of this reduction in arrests may have something to do with the fact that there are fewer people living on the street. And so this is all very, very positive news. We've also seen an increase in dismissal of cases in misdemeanors over time, over years. And so now we see a very high percentage of dismissals. And one might get the impression that that means that there's no accountability in the misdemeanor system. But in fact, in conversations with the leadership team at the district attorney's office, we have been informed that over a majority of these dismissals actually involve people successfully completing certain conditions for those dismissals. And in many cases, that means that the defendants have paid restitution, or that they've successfully completed a program if they were charged with, for example, drunk driving, or some other program. So So this is all very positive news at the lower level of what's going on in the criminal justice system in Harris County, right? So most of the people now are presumptively released. What does that mean? That means that we no longer see some of the poorest and sickest people in our community locked up just because they don't have a couple of $100s to get out of jail. They're no longer being forced to plead guilty because they don't have the money to pay the bail. They can get back out into the community, and Harris County has set up a lot of different programs to try to connect these individuals with social services, with community providers of healthcare and other issues that they have in their lives, to get their lives back on track, rather than having them sitting in jail, undergoing the trauma of being in the jail, and then losing all of whatever they had, their homes, custody of their children, jobs. All of those things are put in jeopardy when people are unnecessarily locked up. So now they're released. And that means they get lawyers for their cases who can discuss their cases with the district attorney and discuss diversionary programs that they will complete and then get their cases dismissed. So they're no longer having to plead guilty to get out of jail, and instead they can work on their cases and have some accountability, but not have a conviction on their record. The final point I will make that hasn't been discussed is this is an issue that touches the communities of color more than any other, right? There was a huge disparity prior to this injunction and this consent decree. There was a huge racial and ethnic disparity in terms of who got out of jail and who didn't. And now we see people getting out of jail without having to pay money. There is virtually no racial disparity any longer. So it really is turning out. And I have to say, like Brandon said, I didn't know how this experiment was going to work out, but it really does seem that all of the predictions of researchers are proving to be true. And we have much better quality of justice. We have better racial justice. And again, the project is only 2.5 years in. There's still many things that need to be done. But things like people getting electronic notifications about their court date, that's a major project that's already been completed. The data dashboard that Brandon mentioned by the Office of Justice and Safety is another major project that's been complete. And that dashboard enables the public to know what's going on in its criminal justice system, but importantly, it also gives information for reporters, for other researchers to do studies, because this consent decree and the results that we're seeing will attract attention around the country. It will become a model because we're seeing empirically that it works. So at least so far, it's the results are all very encouraging and very positive. So I will leave it at that and turn it over to others.
Thank you so much, Professor Thompson. Now we'll turn it over to the County Attorney's Office, to Mr. Seth Hopkins.
Hi, good evening. I'm Special Assistant County Attorney Seth Hopkins. The County Attorney's Office is committed to working with our stakeholders to assure a constitutional and transparent system that ensures public safety. Our role has been to provide legal advice, contract management, consultation, and assistance as needed for departments and officials to comply with their obligations under the consent decree. This includes providing legal support for the data portal and legal support for the implementation of the Indigent Defense Plan. In the next 6 months, we look forward to advising our stakeholders as they prepare a vendor to assist with the training required by the consent decree and helping our stakeholders comply with their obligations under Section 55 to develop a plan to improve court appearance rates. We look forward to continuing to help Harris County.
Thank you, Mr. Hopkins. Now I'll turn it over to the Harris County Sheriff's Office Representative, Major Doherty.
Good evening. My name is Major Patrick Doherty, and on behalf of the Harris County Sheriff's Department and Sheriff Ed Gonzalez, I welcome you. The role that the Sheriff's Department plays in this consent decree is that we process the inmates that are arrested by the law enforcement officers on the street of Harris County. We process and we follow the rules and the consent decree responsibilities that are set out by the court. And we follow those rules and we process the inmates in and release them as the court requires. And if there's any questions or anything we can do to offer some assistance, you just let us know. Thank you.
Thank you, Major Doherty. And then we'll have presiding judge, Judge Genesis Draper, to talk from the criminal courts at law.
Good evening. My name is Genesis Draper. I'm the presiding judge of Harris County Criminal Court at Law number 12. I'm also the presiding judge for all 16 misdemeanor courts here in Harris County. I won't belabor the point. I think the monitors did a great job of kind of updating where we are with the data. As far as boots on the ground, I think we, as the monitors have stated, we are still tweaking things as adjustments are necessary to make sure that we are, one, in compliance with the consent decree, but also that things are functioning well here in the courts. You know, it's already been said that this is a long process. It was not pain-free getting into this unconstitutional mess, and it certainly has not been without pain climbing out of it. But the courts have leaned in and been willing to do the hard work to bring the court system back into constitutional compliance. It's horrible to be told as a judiciary that you are systematically violating people's constitutional rights. And so, of course, it was urgent to get about the business of bringing the courts into compliance. Just to cover a few things that we are still working on, and also to maybe cover at least one of the questions that I've seen pop up in the chat. One of the questions was how SB 6 has affected the consent decree. One of the things, you know, the authors and proponents of SB 6 made clear is that this was not meant to contradict the consent decree. So we are bound by the consent decree. That is a federal consent decree, an agreement that was entered into, and we are bound by that. That being said, SB 6 is largely, particularly where it relates to misdemeanors, is largely about reporting and transparency. And so we are working to make sure that we are in compliance with those requirements. A lot of the things required by SB 6, like a certain data that you review before you decide to give a person a bond, or what bond to give them, or whether or not to give them a personal bond, we were already doing, right? That is information that we were looking at as we did our individualized hearings. That's the beauty of doing individualized hearings and not having a bail schedule. That's the type of information that you request. And so it wasn't a big change in that way. The biggest change is not what we review necessarily in making our decisions, but making sure that we report all the required things to all the different state agencies that require them now. And that is a heavier lift for a county as large as we are, but we are certainly working to get that done. I think Harris County, as well as many other counties, especially the larger ones, are working pretty hard to keep up with those reporting requirements. But as far as the way in which our bail practices are implemented here in the county, I can't say that there has been a huge change, because I think SB 6 also was really targeted for felonies. And so, as stated by the authors and proponents, it is not to be in conflict with the consent decree. They acknowledge that the consent decree exists. And so that hopefully answers that question. Someone also asked about cite and release, and the person rightfully noted that I forget the number that they put in their question, but I had that in my notes that as of just really a week or so ago, 506 cases have been filed through the cite and release process since implementation of that program in February of 2020. And so I do think that that is a area where we can make more use. Offenses that qualify for cite and release, we want to encourage our arresting agencies to consider that, particularly given the strain on Harris County jails right now. And so where we are 500 to 1,000 people over capacity on any given day, we want to make sure that there are not lower level offenses that would be eligible for cite and release that are not taking up those beds. And so we'll continue to encourage that. We will continue to run that court to make sure that that opportunity is available. Additionally, some other things that have been added is the Office of Managed Assigned Counsel. And so misdemeanor courts have created that independent agency that will now oversee the court appointment system. And essentially what that does is lawyers who represent indigent people accused now will be underneath the umbrella of a separate agency, whereas previously the judge made the appointments, paid the vouchers, picked the lawyer, and everything. And so this creates some independence and some oversight and some training and support. And so part of that training and support has been helpful in trying to keep up with individuals, right? Cases are lasting a little longer than we would like because of the backlog and things like that. And so lawyers need to be skilled at being able to keep up with people for an extended period of time. And so that has been helpful in that regard. The only other thing I'll mention, it's hard to talk about bail reform disconnected from the backlog, right? Obviously, the backlog is affected by a lot of things, whether or not it's the pandemic, the displacement as a result of the hurricane. Those are things that were a major impact. No denying that. But bail reform also played its role as well. When you have this many people out on bond and able to fight their cases and demand their discovery and really hold the state to their burden, that is a major change and upset to the system. And so our justice partners and arresting agencies and other agencies that provide discovery are really having to catch up to that. And I think that that's been a really huge adjustment. Now, to their credits, a lot of the agencies have really stepped up, right, and updated their procedures, whether or not it's how they do their body camera, how they process their body camera and turn that over to the state. Several agencies have updated their processes and their technology, and that's been helpful. Of course, it doesn't affect cases behind us, but it can affect cases moving forward. But it is important to note that when people aren't forced to plead guilty to get out of jail, then they want to see their discovery. They want to see the evidence. And we weren't having to provide this volume of evidence before, but we should have been, right? If a person is accused, they should be receiving the evidence in their case. And so while we're happy to be moving in this constitutional direction, it is going to take some time for all of our agencies to really be able to lean in and be able to provide that discovery within the required amount of time. That being said, overall, as stated before, the state of the union is good. The state of county criminal courts at law is good. And we are proud of the work that we have done. And we will continue to do the hard work of maintaining a constitutionally run courts.
Thank you, Judge. Well, thank you all. We've been getting a ton of questions in the chat. And Major Doherty has been on it answering, and the judge also answer some of those questions live. So we do have a few questions that are still outstanding that I wanted to just articulate verbally so that we could all discuss them. So one of the questions is, does the data reflect an increase in misdemeanor acquittals at trial? If so, do you believe that is connected to bail reform?
Just say I don't recall off the top of my head what the numbers were in terms of just trials happening. Obviously, during the pandemic, trials were very challenging to conduct, and there were very few, and trials have picked up quite a bit. There was a trial happening when we were doing our site visit last Friday. I don't recall but I suspect that the change in the number of trials has more to do with, like what Judge Draper was describing, the court springing to life after the pandemic. I suspect in general, though there may be more trials than there were in the days when people tended to plead guilty after a couple days in jail, I would expect more cases to go to trial. We haven't seen, a very high percentage of cases going to trial in general, though. I mean, it's like something like 1%, but I don't have that at my fingertips.
Yeah, I think I would also add, though, that it's not acquittals per se, but I think because more people are out of jail and they have lawyers assigned to their cases who are reviewing body cam footage, looking at police reports, talking to witnesses, they can then approach the district attorney and say, hey, this is a bad case. Here's the evidence. And so, again, we do see a lot of dismissals in the misdemeanor area. And I suspect that there's a fair number of those where prosecutors looked at the evidence and said, it looked like a good case when it was first charged, but upon further investigation, I think we need to drop this case in the interest of justice. So I suspect that that's really what's going on, because these are misdemeanors. So if the evidence isn't any good, the DA is just going to drop them. They're not going to try to fight them, not if it's not a provable case.
All right. Thank you all. We have another question. Are you also studying the drastic rise in electronic monitoring usage in Harris County post O'Donnell? In January 2019, there were an average of 27 people on ankle monitors. By September 2021, almost 4,000 daily average. If folks have to pay for their electronic monitor, isn't this a financial condition of release?
So I'll let the monitors answer if they have the empirical data about the rise in electronic monitoring. And I'm not sure if that number that is being cited includes misdemeanors and felonies. I'm not for sure, but I can certainly believe that there has been an increase in electronic monitoring, because sometimes while we have deemed incarceration is not the appropriate means of supervision, sometimes not as much as honestly in a misdemeanor, but sometimes it is appropriate to go to that level just below, which is electronic monitoring. That being said, it should not be a financial hardship. And so if a person is deemed not to be able to afford it, then the court can waive or reduce those fees. So it's certainly not meant to be a tax on anyone, but where the court has deemed it necessary. And the beauty is, because of these individualized hearings, there is no certain type of case that's going to get you an electronic monitoring. We get to hear from both sides. We get to hear, criminal history. We get to hear the accusations. We get to hear any mitigating circumstances. And so that will allow us to make an informed decision as to whether or not an electronic monitor is appropriate.
And on data, we don't have good numbers on the incidence of those conditions. We have heard anecdotally that there has been a rise in the use of electronic monitoring. I do wonder whether that figure includes felonies as well as misdemeanors. It does sound like a lot, but we've done some informal just look at random cases, and most cases do not involve conditions like that. In most cases, the supervision conditions are not electronic, for example. And one important feature of this consent decree is that if someone is indigent and they cannot pay, they're not to be assessed financial conditions, whether it's electronic monitoring or the cost of interlock or some other device. And so one key part of the protections of this consent decree is that people shouldn't be punished because they don't have money. And so people are not denied release because they can't afford a condition. Like Judge Draper said, those fees are waived if a person cannot afford them.
All right, the next question is, what is the value of studying rearrest or lack thereof? After a defendant's case is disposed, how would a subsequent arrest, while not on bond any longer, days, weeks, or months later, be relevant to a prior bond? Go ahead, Daddy. Were you wanting to answer that?
Well, I can just say that our portion of the report looked at future offending by people who had gone through the pretrial process. And the reason we took that lens is because when a person is initially arrested for the very first time, we know that that arrest couldn't possibly have been affected by the pretrial system, because they've not been through it. They were just released in the community. And so we wanted to understand if once a person did for the first time enter the criminal justice system, if their chance of staying out of trouble in the future changed based on whether they were asked to pay a financial bond versus getting a general order bond to set their conditions in the community. And what we found was that releasing people on non-financial terms makes very minimal difference in their propensity to commit a new offense.
All right. Well, we don't have any more questions in the queue, but we can wait just a few seconds to make sure if there are any additional questions or clarifying questions. Please feel free to put them in the Q&A section. We're more than happy to answer them. And we also like to thank you for your time today. It's so important to comply and to remain in compliance with the consent decree for all of us. And so we want to follow this process through for the next 7 years. As was stated, we're 2.5 years in. So not the next 7, but next 5.5 years. But there are a lot of great things going on, a lot of growing pains, but we're working together to get it done for our community. All right, panelists. Well, I don't see any more questions. Oh, we have one. Just a second. Someone asked how many people are on this Zoom. And so right now we have 30 participants. Any other questions? All right. So thank you all for joining us today. You will get an email with a post meeting survey to ask if all of your questions were answered. Did you learn anything? What would you like to change in the future? Per the consent decree, we have to do this semi-annually. So it's going to happen again in the spring. And we want to get as much participation, as much information out there so that everyone is abreast of all of the movement that is being done in compliance with the consent decree. If you want to review any of the reports, any of the past meetings, all of that is available on the Office of Justice and Safety website, and it's also available on the Monitor website. And we'll drop that link in the chat so that you all can make sure that you are able to view it and see it at a later time. Additionally, if you invited people and they weren't able to make it today, this is being recorded. So you can share this on a later date. And we also recorded the last live meeting, in-person meeting as well. So we have both of those links available and they'll be up tomorrow on the OJS website. So thank you all for your time. Thank you, panelists. If you have any closing remarks, I'll turn it over to you and then we are free to go. All right. Well, thank you all, and you have a wonderful evening. Thank you for joining us.
Thank you.
Thank you so much for hosting. We look forward to the
Thank
next time.
you. Good
And
night.
Bree, And thank you for having this immediately after the Astros won the playoffs.
Yes, go Stros.
Go Stros.
Bye-bye.
Good night.
Bye.